going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Shipkey! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm rich.
What's going on? This is Colin. How's everybody doing? Happy Thursday. Hope you all had a great day. Hope you guys are awesome. Who wants to watch some court? I want to watch some court. We've got some good ones. We start with Judge Colin with one of our very favorite people, Fred's favorite defense attorney, Jessica Blanche. Yeah. Let's go. Let's see. What else do I have to say? Before I start some news, first thing, special guest tomorrow night. Special guest on stream with me tomorrow night, Debbie Davis will be joining me on stream tomorrow night. I'm excited about it. Hope to see you guys all there. I'll say it again, probably about halfway through the video, just when people start rolling in. But yeah, Debbie Davis from St. Joe County is going to be hanging out with us tomorrow night, answering our questions. So that's exciting. What else? All right, you know what? We can end it there. We can watch some court now. Before I hit that play button, you already know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
And Thompson, 24199.
Jessica Blanche appearing on behalf of people.
Just stay here with me for now.
Okay. All right, go ahead, Ms. Jolene.
I'm sorry, did Ms. Blanche put her appearance?
She did.
She did? Okay,
Yep.
I just missed it. Good afternoon. For the record, Your Honor, Erica Julian appearing on behalf of Brian Thompson. I was not sure if this is something where we should take the table or if this will be a relatively quick matter.
I mean, it's your motion to modify.
Oh, no. All right, I know exactly what happened. Heather and I took the Jessica Blanche emoji away to put up the 40th birthday emoji for me. It was only supposed to happen that night. We were supposed to swap them right back. And yeah, we forgot. So yeah, Jessica Blanche's emoji is on the sidelines right now. Yeah, not good time to remember that. Thanks, Legal Fiction. Also, thank you, Fred, for your super chat. Hubba. That's your thing, man. Your thing.
On conditions, I've had a chance to review your motion as well as people's response. So if you want to add anything to that, you can. Otherwise,
Is the court in receipt of the reply that I emailed yesterday at noon?
I did. I think I wrote it all. Motion, response, and reply.
Yes, Your Honor. And the reason why I ask is because I carefully decided whether or not to file this reply. I could have made a lot of this orally on the record, but I felt that the court would benefit from, and the people would benefit from seeing it in advance, unless the court wants me to rehash what's in it or make additional argument.
I mean, it's up to you. I'm comfortable going ahead, or if you want to add anything for the record, I'm happy to take it today.
I think the pleadings, fairly state the parties' positions, at least for our position. All we're seeking is a no non-consensual contact with Christy Thompson. I didn't ask, is Ms. Thompson in the courtroom today? She is present. And just for the court's understanding, the last couple of times that we've appeared in court, she has appeared to want to desperately address the judge, and she has not been able to do that. The judges that we have had so far have declined to hear from her directly, and I'm sure that she would love to speak up to Your Honor as well. I had provided a letter that she had emailed to me that I provided to the court, as well as Mr. Thompson continuing to engage in therapy, and he continues to voluntarily engage with CPS. There's essentially been
Kelly, I heard about that. And no, she has not yet got in touch with me. I hope she does before she writes her appeal, though. So, court vibes, if you're out there, don't submit your appeal yet. Talk to a few people before you do. We can help you write what you need to write. Just so you're aware. All right, let's go. But yeah, if anyone knows her, yeah, she can. It's not just me. She can get in touch with a lot of us that have gone through it that can help her through that process.
And since September, a lot of eyes on this family, a lot of eyes on them individually, a lot of eyes on the entire situation. And while he's criminally charged with R&O with Detective Morrison, I mean, that's really kind of where all this came from. The idea that they are not able to contact or be in touch with each other when they have 5 children under the age of 4, and all these eyes that have been on them, and there has not been a single incident or anything, you know, since all of this happened, and with the no contact. Before I came into the case, back at PCC's, it's my understanding that they were allowed to have family time during Thanksgiving. And then I don't know, subsequently it was denied for Christmas. And I don't know the reasons for that. I was not present for that, but there was no issue with them for thinking, just essentially allow them to try and heal their family. You know, and to the extent it still gives her all of the power. If at any point she says, no, I don't want to see him, I don't want contact, I don't like what happened today, she has the power to do whatever she wants with that. And so that's what we're asking for the court.
Okay, fair point. Ms. Blanche, I had a chance to review your response. Is there anything you want to add on the record today?
I mean, not really, Judge. I think I said it all in my response. I also attached the CPS investigation, which I'm just concerned with the fact.
She doesn't really have anything to say, but she's going to talk for 10 minutes. I know. I'm not complaining either, but I always think it's funny when people start like, oh, let me ask you one quick question. It's not going to be a quick question. If you have a quick question, you just don't say it. You just say, you know, spout your question out. Just like, oh yeah, I'll be real quick. No, you're not going to be real quick. All right. Let's hear her dominate her job like always.
That I get it that it's an R&O. There's also malicious use involving this victim, and there's also numerous assaults where he allegedly punched people during this incident. It stemmed from a tailgate, a Michigan tailgate, and if you watch the video, I mean, he is out of control. He had weapons in his car within arm's reach from kids. I mean, it is highly alarming. And then when you read the CPS investigation and the things that were said and alleged by the victim even after this incident, I'm extremely concerned. And I think that, you know, I hate to say this, but, you know, we've had a lot of domestic violence homicides in our county. And a lot of times we look at them and think, man, there are red flag signs here. Even the mass shootings, there's red flag signs here. And this case just screams red flag to me. It screams that this is someone who has access to firearms, who is, has serious anger issues, not just I'm upset my kid's missing, but irate anger issues that he's taking it out on police, his wife, making threats. And I'm just really concerned, to be honest. And that is the reason why I've been so vocal about not having the contact order lifted. It was lifted for Thanksgiving. I wasn't the prosecutor on the case. I would have never let there be contact between the two of them based on the allegations in the report and what I saw and looking over the police cam. But that was lifted at the time. But I am not comfortable being okay or signing some type of stipulated order lifting the no contact order.
Okay. You know, I guess, you know, so let me ask a question.
Yeah, Judge Colin wasn't ready for that either. He's like, oh wait, whoa, all right, hold on.
Is Christy Thompson represented by anyone?
I don't know that.
I mean, to be clear, you sort of posed it to me like other judges have refused to listen to her.
Oh,
I'm not challenging you on that. I'm
Yes, Your Honor.
saying that I'll bite. I would give her a couple of minutes if she wants to speak to me. She can come up to the podium, but if she doesn't have a lawyer, she's not charged with anything. But the fact of the matter is this becomes complicated. I don't know what she's going to say on the record. What if she says something on the record that somehow implicates your client? So I'm just saying there's a lot of moving pieces here
I do understand that.
And I'm going to say, if she wants to come up and speak, even
Do you guys remember when Caitlin Kirby and Jessica Blanche were both in Judge Simpson's courtroom? Yeah. I think every defense attorney was terrified to walk up to that podium. Those two together, man.
knowing that there's a risk in what she says that could make things worse, there's also not the guarantee that I'm going to just acquiesce to her ask today too, because I have to take into consideration what APA Blanche is proposing. I'm taking into consideration what you're proposing. I'm looking at the posture of the case. We haven't really even had our first pretrial yet. So to some extent, I don't know if Mr. Thompson did any of the things that's alleged that he did. So he's not guilty before he's innocent, but we haven't had a pretrial yet. And caution would indicate to me that this situation is a bit of a complicated one. So if I were to deny the bond modification now, it doesn't mean I'm denying it forever, but it also means that I'm being as cautious as I can. And I don't see this stage of the procedure, even though it seems like a long time from September to now, I get that, but I don't see it this in the, so if he's really eager to put this behind him, no doubt have counsel, he can plead to something and we'll put this, we can do that. I'm not saying that's not legal advice to you. I'm not saying you did anything wrong, but I'm just putting out there that, your lawyer's making a very good argument about how kind of stabilize your family, but I have to be cognizant of what I've also been made aware of in terms of the alarm that this kind of sets off to me. I mean, so that all said, Ms. Thompson, do you want to make a statement?
Ms. Thompson, would you like to make a statement to the judge? Would you like to speak in court? It is completely up to you. Yes? Go ahead, Steve. All the way to the right.
The judge was correct when he said this not defendant, she's technically a victim. She could say something that could hurt this guy, and she's not represented. It's very difficult, very difficult. But she's going to talk. She wants her husband to come home. Wait, no. I remember the story now of what happens. So hold on. Yeah, I'm going to stop talking. Let's go.
Make sure you speak loudly. You're being recorded.
Tell us your name.
Christy Thompson.
Okay. I'm not going to swear you in. This isn't evidence. It's not a trial, but you just need to know that you are placing statements on the record. And, depending on how that, you're not to blame for any of this, but I just want to be clear that it is being recorded and it could be used at a later date, even though I'm not swearing you in. So, okay. Go ahead.
This has been the worst 6 months or so. I'm so sorry. We have 5 kids, 4 and under. You're right, things got heated that day, but afterwards, things were said to me and I got scared. I didn't know what to do because the police were telling me things and it got bad, but I'm now, until March 1st, I'm still living at my parents' house, 30 minutes away from our home. I had the kids in one bedroom that, I don't know, maybe the size of that corner right there. We were all sleeping in one bed. There's mold in the house.
Okay. Well, I'm a family law judge too, so why don't you just move back into your marital home?
Ryan runs a business out of our home. So it's difficult for me to be the one living there. Since March 1st, Ryan has had the kids at the home and I pick them up for a couple hours, 2 or 3 times a week. And that's all I see them.
So that's heartbreaking.
We have a 10-month-old.
Right. But I'm also, I mean, let me go back and say allegations are that in the car, in the vehicle, there were firearms there. So when APA Blanche says this, she's not saying it to punish you. She is saying she's worried about your survival. The largest.
Okay, and it's frustrating to me for people to say that I can't defend myself or I can't that's been through all this.
All right, stop. No one's saying you can't defend yourself. That's not what anyone's saying. That's not what Jessica Blanche is saying. That's not what the judge is saying. Yeah, this is her husband's attorney needs to step in and be like, okay, we're done. Because now it's put in the minds of everybody. Why would she have to defend herself? That's the opposite of what she should be saying.
I've sent multiple emails. I've made my wishes clear, like, and it's all like, you can't defend yourself. Like, I'm this weak little individual, and that's not the case. Like, and instead, our family is just being torn apart. Like, we have 5 kids, 4 and under. One of the oldest ones, back up. We have 2 sets of twins, 4-year-olds, 2-year-olds. We have a 10-month-old. Like, it's heartbreaking to see now. It's not heartbreaking, but they've been with Ryan since March 1st, living back in the home with him. Like, one of the 4-year-olds is now potty trained. He would refuse to do it at my parents' house. 2 of them go to speech therapy, one of them being the one that has autism. Like, he's talking now. Like, we've missed all the firsts with the 10-month-old. My birthday was Saturday, like, and I did nothing.
So I guess though, here's where I'm sitting. And we're kind of at the end of where I can discuss it with you, because now if I ask you more questions,
I
it
understand.
gets into your history with him. And not really fair to you to put you in that position. But from the allegations in this case, I don't know the truth of your relationship with Ryan. I don't know the truth of your ability to protect yourself. I'm not being a smart aleck when I say to you, I bet you're pretty strong. The fact that you have that many kids under 5 would immediately strengthen you. But the fact is, you're not, as far as I can tell, Supergirl. So bullets would kill you. And so that to me is a bit of the game changer in terms of statistics. The number 1 cause of death in women between 25 and 45 is homicide. It isn't illness, it isn't cancer, it's homicide. I'm hopeful that this all resolves in a domestic, meaning family law way that's appropriate. If you stay married, that's great. But I'm also saying that what happened that day is way beyond the kind of, I'm freaking out because my kid is missing. Like, it's so far beyond that you're hearing everyone in this room saying, we're worried about you. And I'm not saying that to be condescending. I'm not saying that to be insulting. But how would I look at your parents in the eye if you died because I said, this is okay, you're fine? How would I respond?
Fighting to get me to go back home.
Okay, well, and I hope that in the end, if that's what's best for you and your family and your husband and your kids, that happens. But all of this is the result of the actions of that day. And if there's caution, it's not that anyone's trying to control you, but we are involved in this case right now, ma'am. The state is involved in this case. And so at this point, I'm not going to modify the bond condition. We haven't had our first pretrial yet. So I want you to hear me, Ms. Julian, you can explain this to him. I'm not saying that if he pleads, I will modify his bond condition, but as well as I do that progressing in the case in terms of moving toward resolution is an indicator potentially of stability. You're free to make your bond argument again, whether it's apropos of nothing or if he's pleading or there's another event that would raise that. I'm willing to listen to it. I am. But I'm just not going to do it today. There's too much volatility here. I'm just reading this all for the first time. So it's not like I'm steeped in the lore of this family. But, reference to D. Warner, that's chilling to me. The CPS stuff is chilling to me. The weapons, the guns in the car. It's not like he has guns in a safe at home. They're there. So again, this could be not only the death of you and your children, innocent bystanders and all that. I'm not saying that that's going to happen. And Mr. Thompson, you're shaking your head, but somehow we're all in this room together. And somehow it's the actions that happened that day that have led us here. So I don't know the truth of what happened, and you'll have your opportunity to speak your side of the story in court. My job is to try to keep everyone safe.
Yeah, I think that's the right decision. It's way too early to start changing that. It sucks, but it's on your husband. It's his actions that put him in this situation, that put your family in this situation. So she can be sad and upset with the court right now because she's frustrated. I get it. But yeah, the court has to do this, and I understand it.
And so, despite the chaos that may bring to your family, I mean, number one, I didn't bring the chaos to your family, but number two, I just got to do what I can to keep everyone safe. I'm not doing it lightly. I'm not doing it jokingly. I hear you, ma'am, but at this point, I'm not going to make that change. And then if there's a reason in the future, I'm perfectly willing to listen to it again.
Thank you. I understand the ruling and I'm not asking that, obviously.
Rachel, recently Heather bought me a chair for my little streaming setup. And, it was one of those swivel chairs, and I absolutely hated it. I hated it. I did not like it at all. But eventually I came around.
I did want to put a couple of things on the record.
Go ahead.
Just based on the ruling. First of all, as part of working with CPS and as part of that entire process, since last September, October, there are 0 firearms in the home. They are all at his parents' house. And that's part of his plan with them as well, is that there's not access to firearms. And I did put in the reply that we actually have, so this is tough when we have cases where bond and allegations kind of fly together.
Sure. I know.
Whether or not what his behavior was that day rose to criminal, he was not arrested that day. This was authorized sometime later. And it seemed to track with the CPS part of the investigation. And so as a lawful
TYP, that is a great point. I didn't think about that. He's got a no contact order with his wife, not the kids. That's a very good point.
And I did put in here, he flatly denies that they were in the front seat and easily accessible and all those things. And
that's fair that he does. I mean, I appreciate you putting that on the record, but I can't take that at face value because we're not at a trial right now.
I understand. I just want to make sure that I make a record on his behalf. And then in terms of the allegations that the people, and I represented in here that they argue them as if they really happened or as if they are true. And that when Ms. Thompson had initially made these allegations immediately after the incident, she had never made allegations like this before. There's not past police reports. There's not like that. He's never been charged with domestic violence. It's not like that. And that she had kind of immediate aftermath. And there's no question, and this isn't even, whether what happened was criminal is a different thing than what happened. Was he a big jerk? Yeah. There's no question about that. And he acknowledges that he's a big jerk that day. Okay. But with her statements afterward, they're now being treated. And I understand.
Fozzie, it kind of looks like she's reading the chat. This was filmed yesterday, or this hearing was yesterday, I believe. It was either yesterday or the day before. So yeah, this didn't happen today, but it looks like she's reading chat right now.
I'm not trying to challenge the court or people, in that manner, but that they were just statements, that they were words, and that she was using those to posture for a potential divorce or a custody thing. And she recanted all of those statements within a month, saying, I said all that and I didn't mean it. And I had spoken with Brian the entire time about the things that she said immediately after this. Those are, that's just going to continue to be part of the case. And so where she had wanted to regard the court, but where she wanted to communicate to the court regarding her postpartum depression diagnosis and medications that she started taking, and therapy that she, all of these are her, in her situation.
And she's not on trial, meaning that I'm not saying that maybe she did say things she didn't mean and maybe she did recant them, but again, I can't, just in my life as a judge, in my history, I can't turn a blind eye to, to things that may or may not be how, because you and I weren't there that day. And, to be clear, I'm not saying I'm not saying anything about anything you did. And I'm not saying about anything your wife has said today or before, but this is serious business. And it's risen to the level of alarming business to me anyway. And so I'm sorry that we're here like talking about this, but at the same time, if this were somebody else who had done this, who was close to your family, and you would be outraged if I were sort of turning a deaf ear to what I'm supposed to be looking at. So I know it's messy and I know it's not easy, but I got to make maybe the hard decision today. But let's hope that this results in kind of some resolution. Whether it's a plea or whether it's a not guilty verdict, then we'll move to the next steps. And in between then, this discussion can be revisited.
We are currently scheduled for pre-trial next week, and obviously not.
All right, I'm going to set the record straight. She's definitely winking at Fozzie. I mean, it's obvious. She's been looking at his comments all night long.
Nothing's going to happen with this particular case. So it's like the legal and the bond following each other. There are a lot of legal arguments that we have about the charges that make it difficult for him to want to render any type of.
Sure.
On the other hand, I know that we've also requested Michigan State Police body cam and records, and the people, Detective Morrison has apparently requested those several times. I know that Michigan State Police is very slow in releasing their discovery, but there were two. They're bike officers or whatever that they had body cams in the immediate vicinity of things that were going on that are alleged. And we really need to see those because some of the body cams were turned off on a sheriff department during some key moments that are now in the reports. So
I mean, I don't know. I mean, you're sort of obliquely alleging some sort of conspiracy theory thing.
Actually, I'm not.
But at the point, like, I'm happy to adjourn the pretrial if that's what you're asking. If you don't want to adjourn it, we can come back next week and map out kind of next steps, like when you're going to file motions, when you're going to get discovery. I'm fine to adjourn it, or I'm fine to hold it next week.
I guess the only question that I had from Ms. Blanche was whether if we just went ahead and started moving the case now to see if we could resolve it short of a trial. So I don't believe that there's going to be something immediately that we're going to be able to do. Have a suggestion for how far out we should put that. I'm sorry.
No, just so I left for vacation, but I got a USB the day I left for vacation, so I have to tender that over to you. So that'll have probably everything you're asking for right now. So however long you need to review that, then just set it out, I guess, at that point.
Okay, can we set this for pre-trial done in 2 weeks? Ms. Blank, will that be enough time for you to be able to discover the USB to me?
Yes. Yep.
2 weeks would be the 17th, on the 7th.
You need it from
So we can adjourn this to.
I'm sorry, so Mr. Thompson is a dog breeder. He's got puppies too the day before that, so he's got new litters. You want to go to me first? If we could put that pre-trial in.
But okay. All right, May 1st at 1:30. All right, see you back here then. Thank you.
Thank you, Your Honor.
Okay.
Oh, that one was a little bit tougher of a case than I usually like to cover, but did it for Fozzie. Legal Fiction, Winking Jessica Fund. Thanks, Legal Fiction. And Fozzie, of course. Vacation, where we're going. Yeah, you misheard her. She said that she got it before she went on vacation. She's back now. But you know what? I don't want to ruin your dreams. I don't know where she's taking you. I don't know. All right. What are we doing next? See? All right, here we go. Heather's here. Yep. I told him earlier, Heather, that what happened. We had to substitute it out. We only get like 25 emotes, so we had to remove one to put in one. And I was thinking about removing Fozzie's, but yeah, we took Jessica out instead. Fozzie again for $5. Thank you so much, Fozzie. Pause the video. Need to go get it. Oh, I thought that was going to go inappropriate. Okay. Drool. Okay, that's fair. I thought I started reading that and I didn't know where you were going with grabbing it. Okay, you know what? Let's go. Judge Boyd. We're headed to Judge Boyd's courtroom where, yeah, don't lie to the judge. Don't lie to Judge Boyd. She'll give you a mom speech if you do. And that's what happens. Let's go.
Hi, thank you for dressing appropriately for court. I appreciate that. All right, court is calling 2024 CR 0501, State of Texas versus Ernest Gonzalez. Can I have parties announced for the record? For the state,
Daniel S. Barr for the state of Texas.
defense,
George Sharman on behalf of the defendant.
and are you Ernest Gonzalez?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your?
That has been a question that my parents have been asking for a long time. Speaking of which, it's my mom's birthday today. Happy birthday, Mom.
Client?
Yeah.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? You're going to need to speak up.
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Gonzalez, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did. Yes, ma'am.
Off the record. Excuse me, sir, in the green shirt, just have a seat. We're back on the record. Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understand.
Did you understand by entering this plea, you were giving up those rights?
Yes,
And did you intend to give up those rights and enter into a plea in this case?
I did.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
I do, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He could. Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
he is. Yes.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. This will run concurrent with county court cause numbers 709684, 709685. There's to be the DWI education course VIP, ignition interlock for half the term, and you agree to forfeit the weapon, and county court cause number 709684.
Yeah, he's still well behaved right now. Just wait. Just wait. We gotta get through all the court stuff before we get to the I don't want to say the good stuff because it's not good for him. It's good for us though.
Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do.
Counsel, have there been any such motions?
I'm sorry.
Have there been any such motions?
Regarding.
Have you filed any motions in this case that have
Oh,
been ruled
no.
upon?
Mhm.
Outside the agreement, the state is requesting that your community supervision be set at a cap of 5 years and there be a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
I understand, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states Exhibit 1 in all attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understand.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports and lab reports, but most importantly, there'll be no live testimony. Did you understand?
I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt because you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge, and I do have some comments.
All right.
After we leave here today, we're going to go down to County Court 1. We're going to accept responsibility for those matters down there. My client has taken this very seriously, and he's taken responsibility for his actions. The state did recommend a cap in this case. This is a first offense. It was a DWI initially, and this was the result of a search. What we're asking for the court to do is to allow him to have a deferred period of less than 5 years. That we're asking for 3 years because we believe that he can do well. He can demonstrate to this court that he's serious about this and that he will correct his behavior. So I'm asking if the court would consider a lower sentence of probation of 3 years.
All right, State.
Judge, due to the facts in this case, I think that 5 years.
All right. Now listen to the facts of the case. And yeah, let's just say it's about, well, that would have sounded a lot better if I didn't choke on my own saliva. It's about to go down.
Is appropriate. He was found halfway in between the parking lot and the sidewalk, asleep in his vehicle with a gun in his waistband. There were several open containers of alcohol in the vehicle. Again, that's all something that's highly dangerous to the community. When he was further patted down, they found the drugs in his pant pocket. Whenever the officers began to interact with him, they saw that he was exhibiting several signs of intoxication, including the smell of intoxicants, being confused. We just think that 5 years, due to the nature of all the offenses together, would be appropriate.
All right, I have a few questions for you. So how often were you using it?
Wouldn't be a video of mine without a little editing mistake. Let's jump forward.
Whispering court, but when they're talking to their friends, they're not.
The whole time I've been here. I don't know. Maybe.
All right, so maybe it's my allergies that are acting up.
Might as well.
But speak up. You hear at the level I'm speaking?
Yes.
That's the level I need you to speak.
Okay, we'll do.
And I don't even have much bass in my voice. It's all treble. So I know you have bass in your voice. Use it, speak up so everybody can hear.
Yes, sir.
So how often were you using drugs?
Maybe once a month, if that.
Okay. So let me explain something.
Did you see the little side smile? No, you weren't, man. You were found passed out in your car with alcohol surrounding you and drugs on you. You're not using it once a month, man. You're not.
To you.
Yes, sir.
You've already entered a plea, right? I'm trying to make a decision on whether or not to set your probation at 5 years or 3 years. That's either yes or no. You understand?
Yes.
So there's no need for you to downplay whatever is going on in your world. And let me just tell you why. I'm inclined to follow the agreement that you've reached with the state, which is to give you deferred. The only issue right now in my mind is trying to figure out how long your deferred should be. So what I can tell you is when people are not honest with me about their drug use, and that's what we're ultimately here for, that tells me where you are on the level of your sobriety. So I've read the police report, and in the police report, you were passed out. You had meth. You even admitted to the officers that you had just used some meth. So passed out in a vehicle, surrounded by alcohol, having used meth, and then have meth in your pocket, that doesn't sound like I only use once a month. So how often were you using? And most importantly, if you drug tested today, what are the results going to be? You're going to get drug tested today.
Yeah,
so you need to be honest.
Marijuana, of course, and then alcohol.
All right. And anything else?
No.
All right. Are you available to do a UA? All right, we're gonna come back with your sentencing once I get a UA. Do you need any water?
Sure.
Well, I mean, you say sure. Do you need
Yes, Your Honor.
you need water or not?
Yes, Your Honor.
All right. So what's going to end up happening is he's going to provide a UA to the court, and then I will make a decision on your sentencing. So if you have a seat in the front row, please. All right. Thank you.
All right. So we're going to wait to go to County Court 1.
All right, that's when you say, all right, you know what, Mrs. Ma'am, Judge Boyd, yeah, you're gonna find a lot more in my system than just that. Just this is what's gonna happen. She was very nice and asked him to be honest. You know, marijuana's not legal. He said that. He didn't want to say the harder drugs.
All right, we're back on the record in 2024 CR 0501, State versus Ernest Gonzalez. So, Mr. Gonzalez, you were previously under oath. You're still under oath. How many children do you have?
2 children,
What are their ages?
12 and 6.
And are you employed?
Yes.
What do you do?
I work for the U.S. Postal Service and for the National Association of Letter Carriers.
Okay. All right. So, your test has come back. What do you think it's positive for?
Mainly THC problems, some alcohol, and then obviously what I was charged with.
All right. So why were you up here? See, this is the thing about people in their sobriety. You already knew that I was going to follow this agreement and give you deferred adjudication, correct? You knew that.
Yes, sir.
And you still were dishonest. Now you're changing it. You told me you would not be positive for meth. You told me you're only going to be positive for marijuana and alcohol. Did I hear him incorrectly? I know my allergies are acting up, but isn't that what he said?
That is, Judge.
Isn't that what you said?
Mainly THC.
No, don't do this mainly thing. I asked you if you would be positive for meth. You told me no. And as a matter of fact, I said, how often do you use meth? And you said, not often. And I said, what does often mean? And then you said, maybe once a month. And then I said, I've read the police report. In the police report, you have meth in your pocket, you have meth in a bottle, and you have alcohol surrounding you. That doesn't sound like 1 month use to me. And then I said, well, let's wait a little bit. We're going to have you do a drug test. And I said, this tells me where you are in your sobriety. If you're going to be honest with me, that's a synopsis of our entire conversation. And then I told your attorney was right here because your attorney is asking for you to be placed on 3 years deferred adjudication. And you walked back to probation. And let me just tell you what I'm assuming happened. As you're walking back to probation, you're praying to whoever your higher power is, saying, if you let me be negative for meth, I promise I will never use again. You know what ends up happening when you do that? Sometimes your higher power will be like, okay, we're going to let you be negative. And this court usually, you know what the answer is? For your betterment, the test is going to be what it is. And so you're positive for meth. So now we're back to, how often are you using?
About 3 times a week.
All right. So we go from once a month to 3 times a week.
It's a big difference there. And like 3 times a week, man, I'm not going to say that means every day, but if he would have first said, I use it about 3 times a week, and that was his first response, maybe. But when you go from once a month to 3 times a week, he's in so much denial about his drug use. And this is when he needs to come clean. Judge Boyd will help him. She will. Spoiler alert, she doesn't throw him in jail. He doesn't go to jail, but he doesn't get the 3 years that he wanted. He gets the 5.
It's embarrassing, so I apologize.
Well, I mean, here's the thing. Where we are in our life, hopefully this is not where we're going to be 2 or 3 days from now, or a month from now, or 2 years from now. Guess what? Every person in this courtroom, okay, we're on the record. We're on the record, talking with the court reporter while we're on the record, or the court coordinator. Here's the thing. Everybody in this courtroom are working on something in their life for improvement. believe it or not, Stephanie Boyd is not perfect. I'm working on improving things in my life. I'm always working on my patience. I'm sure everybody in this courtroom has something they're working on in their life to be better at. And where we are now is hopefully not where we'll end up, that we will have improved on whatever we're working on. You understand?
Yes, ma'am.
All right. So what I'm going to do for you, part of it is punishment for being untruthful to the court. I'm going to sentence you to 5 years deferred adjudication. And I will tell you, when I was reading your police report and reading the steps before your counsel even said anything, you know what I had written down on the sheet of paper where I write my notes?
I can't see that.
Oh, 3 years deferred. That's what I had written. So these 2 years that you're getting on top of the 3 years, that's not your attorney's fault. That's all on you.
I accept that.
All right, so 5 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be the UA hotline. There's to be a referral to felony drug court. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And don't mix up anybody's mail. Okay. There is to be field visits 1 time per month until in treatment. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once he completes the parenting classes, the community service hours will be deemed satisfied. There's to be no unsupervised contact with minors.
Get out the bed. Get out the bed. It's time to go to school. Get out the bed. Oh, I can see that legal fiction. I can see that. Also, while I'm paused, thank you so much, Mary, for the super chat. Hold on, I'm trying to bring it back up. Thank you. Thank you, Mary. Thank you so much. Generous of you. I like Boyd, but I'd be so nervous with, I feel like I was lying even if I wasn't. Yeah. If she has that, I feel like I'm talking to my mom vibe. And yeah, you don't lie to your mom. You don't. Annalisa Molina. One of my favorite names on the internet. It's just so much fun to say. So much fun to say. Hi, Colin. Did Court Vibes reach out to you? YouTube just put her in jail and she doesn't know why. She has not reached out to me. Someone asked this at the start of the stream. I did hear about it. And yeah, I would love to be able to help her. So I hope she does. I hope she does reach out to me. All right, let's go. All right, next clip after this one. Just a little sneak peek. Liar, liar, pants on fire. Judge Simpson court's back. That's coming up next.
That includes your children until further notice. So if you're going to be with your children, there needs to be another adult that are supervised. You understand? This is run concurrent.
That question got me in trouble today. I was in Judge King's chat and he actually read my comment about him slipping from my favorite judge to my number 2 favorite judge. He didn't like it too much. Even though I was joking. I don't have a favorite judge. Not gonna go down that road. Terry Barnes, thank you so much. You rock, Terry Barnes. You rock. Thank you. Thank you for the super chat. Very generous of you. I sure do appreciate it. I have been working on that accent. You can tell. Sparkle Poots. You guys are all like hitting it while I'm paused. Thank you so much for the 5 gifts of membership, Sparkle Poots. I appreciate it. And welcome to the new members.
With County Court cause number 709684, 709685. You're to forfeit the weapon. And cause number 709684, DWI education course. And counsel, if in misdemeanor court they require the DWI education course, of course, that will be satisfied for this court.
Yes, Your Honor, we're going to do it concurrent with the probation in this case.
All right. So DWI education course, VIP live, ignition interlock for half the term. Probation, is there a $500 fine? And that will be probated. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful? Oh, and probation, in case he's not accepted in felony drug court, do a TAP evaluation and 90 sober meetings in 90 days. And if TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you. Off the record, here's the thing. You want to make your children proud of you. So if you're not going to do it for yourself, being clean and sober, do it for your children, okay? And thank you for dressing appropriately for court. I appreciate it. All right, good luck to you, okay? If you need anything and you feel like probation is not addressing it, you can always come back to the court. All right, thank you.
All right. All right. Yeah. I like how she ended with, thank you for dressing nice to court. Also, the little joke she dropped, don't mess anyone's mail up. She was trying to be positive with him when she was kind of, getting down on him for lying to her. But, don't lie to her. Don't lie to her. All right, where we go. Okay. Now, I will tell you, after I made the video for tonight is when I found this in Simpson's court. So I'm going to have to fast forward through my intro, but this is Liar Liar. I'm going to fast forward to this. This was going to be my premiere for tomorrow, but we'll just play it tonight. But this is Liar Liar, Pants on Fire. You guys all remember her. All right, let's go.
Court does call the case. People of State of Michigan versus Julie Van. Oh.
Good afternoon, Your Honor. Warren Green on behalf.
You're right. I did not pause to say hi to Rachel. Rachel. Hi, Rachel. It's good to see you. Thank you so much for coming. I haven't talked to you in so long. I hope you're having a great night. Thank you so much for being here. All right. Feel better now, Fozzie? Thank you for the super chat. Hopefully that made you feel better, Fozzie.
Of Ms. Vongfachan, State Champ.
Julie Vongfachan.
Your Honor, today's for a motion hearing before the court is the defendant's motion to modify bond. Our motion is based on MCR 6.106. Your Honor, when we filed this motion, it wasn't our intent to try to distort the law or the facts to make an argument that somehow the court is bound to reduce her bond or grant her request. I think we know what the facts are leading up to this, and we know what the law is on whether the court can deny bond in such an instance. What we did was we laid out what we felt was a full.
She'll never beat Jeffrey Bloom. He's the all-time leader in court videos right now. But who knows? Who knows?
Fair account of the actions leading up to this. And I don't think the people denied any of those actions leading up to this just from a purely scheduling standpoint and from the standpoint of Ms. Vongfachan's bond violations. What I wanted to draw the court's attention to was that prior to Ms. Vongfachan's engagement with the criminal justice system in this case, she had previously engaged in behavioral health.
Is it Jeremy? I said Jeffrey. Jeremy Shue. No, I said Jeffrey Bloom. Jeremy Shue's up there too. Okay. Jeremy Shue, Jeffrey Bloom, two different people. All right. My mind just crossed wires there.
Counseling. She was going to Apex Behavioral Health in Westland. I included the date in our motion. I mean, the address in our motion, but she was doing that until January of 2023. The way Ms. Vongfachan described that to me was, I think some of the behavior the court has seen through the bond violations it's heard is that Ms. Vongfachan, for some reason, when confronted with an issue in her life, at first blush, her first reaction is maybe to be dishonest or wiggle out of a situation. And I think she sought help with that exact behavior before. So our primary argument in support of the court granting our motion would be so that Ms. Fong-Fachan could re-engage with that kind of counseling. Of course, Ms. Fong-Fachan is fully aware of what her bond conditions were. And
Rachel, I have no idea. I wanted to know though, because she has some kind of online community that I want to just look up to see what she did while she was in jail. Because she called into her podcast while she was in jail. And I wanted to look that up, but I have no idea how you spell this woman's name.
will remain fully aware of what those are if the court does grant our request. Ms. Fong-Fachan will or cease using any intoxicating substance during the pendency of this case. I know she wants to seek reemployment for the job that she lost as a result of her actions. And I think she acknowledges that the delay and the turbulent bond release she's had so far have been her own doing. I think the time she spent in custody, she's had an opportunity to reflect and to think about how she wants to move forward. I think she wants to head in a positive manner towards resolving this case. And we would be asking the sentencing court to consider probation still. She knows that her bond violations are going to be considered by the sentencing court in determining sentence at the resolution of this case. So, Your Honor, what we're asking the court to do is reinstate her previous bond. We're asking the court to keep the previous bond conditions in full force and effect, and that the court modify her bond such that she be fitted with a scram alcohol tether prior to her release if the court grants our request.
Is there anything additional from the people?
The opportunity to review the counsel's motion and file a response to counsel is correct. I did not deny any of the allegations in there. The only additional information that I did include was my knowledge of the defendant's CPS case regarding her children. But at this point, I would leave her current status in the court's discretion. Thank you.
Was there anything you want to say to me?
I just want to say thank you for allowing me to have a motion hearing.
Tell me why I should let you out. Because, and there's a reason why I'm asking.
No, she kicked his business front door in. It wasn't his house, it was his business. But that's what started her. That's what got her in this trouble. But yeah, she kicked the door of her boyfriend's business. Or is it boyfriend or the father of her kids? I think it's the father of her kids. So ex-boyfriend or ex-husband, I don't know. But yeah, and then she got into a fight with the police.
And so it's clear. You know, and the facts of the case were relayed to me last hearing that we were on. Or the alleged facts, I should say. I'm amazed that you took something that was a misdemeanor. I don't want to call it a simple misdemeanor, but a misdemeanor. And something that more than likely you would have never spent any time in jail on. And somehow on the date of that offense, parlayed that into a felony charge, or at least a high court misdemeanor charge. I don't even understand how that happened. But even after you did that, then have a case that you still wouldn't have spent any time in jail. And all you had to do is just follow the rules. That's all you had to do.
Thank you, Fred, for the super chat. All right. Let's stop making fun of her last name. Let's come on. We're better than that, guys. All right, we had our laughs. Let's not make fun of her last name though. We're better than that, even though it's kind of funny.
And then somehow or another, you've now spent 3 weeks in jail on something that you would have spent no time on whatsoever. And I don't get it. I really don't. I say all of that to say, I feel like this is almost Groundhog Day. I bring you back the first time after the first week, gonna let you out, find out what you've done while you've been in jail, can't let you out. You spend that second week. Then I come back the second week, I let you out. Don't make it a day before you broke the bond conditions. Then next thing you know, next time you come back in, I gotta throw you back in. And now here I am again. So it almost is that old saying, why should I repeat and do the same thing? Because that would be insanity on my part. Tell me why it wouldn't be. You tell me why I should take a chance on you.
I had some time to sit down and think for these past few weeks. I won't do it again.
You lost your job. You missed your kid's birthday. For what?
For my actions.
Did we print off that communication I received?
No, but I can.
Counsel, I received.
I agree with you, legal fiction. I agree with you. She could have said something a lot better, but we got to go back and look at the history of this defendant. Every time she talks, she goes to jail. I honestly think my actions was the best thing that she could have possibly said, because she's not getting herself in more trouble.
An email, which I'll just widely print out. I actually meant to have a copy here, and that's my fault, so that you could have that from, I guess, the father of their children, their partner. I don't know if you've seen that, whether that was sent.
Yeah, there's some long pauses in this. I think I fast forward a few times. We'll see.
Yeah.
Judge Simpson takes his time on this one. He doesn't want to keep her in jail for this. But she's lied to him. I don't know. What are we on? 37 times? That's 42 times. I've counted.
Daniel Gray, and I'll just indicate to you, I mean, I'll let you read it through, but as you read through it, the person that I am reading about in this is not the person that's been appeared before.
Another one of those awkward pauses. What to do? She almost gets herself in trouble here shortly too.
Yeah, Your Honor. Yes, I did.
Hmm?
Yes, I did, Your Honor.
Anything you want to say regarding that?
Your Honor, I do appreciate Mr. Gray's kind words about my client. I think one issue that Ms. Fongfichen has dealt with for probably her whole life, but at least since I've come to know her, is that she has a remarkably difficult time kind of opening up and
Of doing what?
opening up to people. And I think that's one of the reasons she was engaged in counseling before, was that it has taken us a long time to kind of develop an attorney-client relationship, just because there's something in Ms. Fongfichen's past, I'm not sure what it is specifically, that has created a situation in Ms. Fongfichen's life that she just has a difficult time kind of opening up and being truthful about what's going on with her, what her feelings are. And so I think the sentiments reflected here by Mr. Gray, who is presumably someone that Ms. Fongfichen has opened up to, probably give a more accurate picture of who she truly is than I can give to the court, or that even Ms. Fongfichen can provide to the court herself.
Where is Heineken when you need him? I'm pretty sure he could fix her.
Have you gone through with her what her bond conditions are, counsel?
Your Honor, I have, and I believe that the bond conditions that previously existed are clear to Ms. Fongfichen now, but I would give her an opportunity here on the record to ask if she needs any clarifications or additional explanation about what the terms of bond are.
No,
Are you certain?
sure.
Okay. And you understand that there has been no modification to the previously instated no contact order that allowed for limited contact with Mr. Gray for purposes of raising your children via text message. You understand that?
Yes.
Okay. Your Honor, something the court would, based on this correspondence, consider modifying today?
Modifying what?
The no contact order that was previously in place between my client and Mr. Gray?
No, and you know, I'm not gonna do that. I mean, and here's my reason. I'm not trying to be harsh about it, but that condition was in place from the get-go, right? And you know, I think I indicated this to you, counsel, that when she came back and there were all those calls, I think I told you, because the communication regarding the children was supposed to take place by text message, that I could even forgive a couple calls a day. You know, I would just, without even knowing the content, I would just have to say she can't have that form of communication. But that's not even what happened. I mean, she didn't, it's not even just about not following the rules. It's like she wants to play by her own rules. And I hope she understands this is what you get when you play by your own rules and they come in contravention to the court rules. This is what you get. So I'm not going to change anything. I just want her to follow what was originally set. Just do that and I can be happy.
Understood, Your Honor.
And don't say you don't know. Chuck, don't say, I didn't know I couldn't drink. You got an attorney. You can ask your attorney, can I do this? After I threw you in jail for 2 weeks, it would seem to me that the first thing I would have asked my attorney.
Yeah, I can message him. I don't feel like it's been that long since the last time I saw him, but yeah, I'll message him on Discord tonight. I'll actually do it right now, so don't forget.
Getting out or before is what can I not do? But you didn't do that. That next day you were drinking. Do you still have a job even?
No,
So what are you gonna do?
I don't have a job. Like, I lost my job, but on the weekends, I throw a party on Saturdays.
Your Honor, I think what Ms. Bonfachan means.
Yeah, this is, this is one of those things you don't mention. You just don't say. He was asking about your job, not what you do for fun. She's a party planner. She does her social media thing, and I don't know. She probably charges entry to get into her party. She probably makes some money off of it, which is why she's calling her podcast while she's in jail. She wanted to continue that online personality. Look at Chili. He did it. He got himself in trouble too. Just one of those things you don't tell the judge right now. He didn't ask. Do you still have your job? No, I lost it. I might be able to contact them when I get out to see if there's any shot at getting it back. Done. End of conversation. That's not lying.
To say is she was in the business of promoting events and parties.
I know, and that becomes a problem because you just made this a mess.
Your Honor, I think if she's on a scram tether, she would refrain from partaking in any activities that would violate court's orders. She would, of course, still be subject to the drug testing requirement that was previously in place. I understand that environment.
But these things are promoted on the internet.
They are.
And one of the conditions I was going to have is that she can't appear vocal, oral, or otherwise on the internet. So how's she do what she was doing without doing that?
Ms. Fong-Fichan, is it possible for you to continue the business you're in without using Instagram or other social media as a way to promote your business?
I guess I just have to stop.
Okay, but is it possible for you to continue your promoting business without using social media?
And that's how we promote the party. So,
Okay.
no.
Oh, dear God.
Are you able to seek other employment or
I'll
reemployment at
look
your
for another
previous
job.
job?
I'll look for
Okay.
another job.
Are you able to get in contact with your union representative at the University of Michigan to see if there are ways that you can seek reemployment where you previously were working?
Possibly.
Okay.
Thank you, Legal Fiction. Saturday party fun. Let's go. And yeah, the attorney said exactly what I said a minute ago, which was probably in my head because I've already seen this. So I'm not going to take credit for it. But yeah, listen to your attorney. That's all you got to do. Listen to your attorney. Tell him the truth.
You know, ma'am. Frankly, for the most part, had you gone on social media after being in court, I could have cared less. But it's what you did when you went up.
Understand?
Well, what was in your head to call from Washington County Jail? Really, what?
Yeah, she was self-bragging though. Like, oh, well, I do this on weekends. She couldn't help but promote herself because that's who she is. And now we're going to talk about the jail calls.
I don't know.
What? No, you had to have. Don't tell me I don't know. What the heck were you thinking? Have you heard yourself on that podcast when you call from the jail?
I haven't. I heard one clip, but I haven't watched it.
Judge Simpson's thinking mode again. And you know she is sitting there nervous. Judge Simpson doesn't go quiet very long. This was a 7-hour docket. Even in between cases, he's talking to everybody. Pretty sure if he had a YouTube channel, he'd pause more than I do. She's 34? I'm telling you, I have lost my skill of guessing people's age.
23rd, correct?
Being a bartender for a while, I got pretty good at guessing people's age. I was guessing like 24, 25. I was way off. Samsonite. I was way off.
Stupidest thing ever. I'm gonna tell you what, man. You better thank that man standing next to you.
Yes, that is absolutely happening tomorrow. Debbie Davis will be on my stream tomorrow night. Live with me, answering questions, interview style. Yeah, that's happening tomorrow night. Hopefully you guys all will make it.
Because I'm gonna be absolutely honest with you. The way I am, if you had, I'd be so done. And you just wouldn't see the light of day if it weren't for what arguments he was giving me. And at least the faith and hope that he has in you that you can just do the right thing for once. He has that faith. I'm not sure I do. But he's convinced me. I'm going to give you another shot. God help me if you had come back. God help you. Because I don't know who's going to. I'll reduce the defendant's bond to a $25,000 personal recognizance bond. I'm going to add all previous conditions that were originally set are reinstated. You understand that?
Yes, Your Honor. Thank you.
There's to be no appearance, or vocal, oral, or otherwise on any social media platform. Defendant is to be placed on a scram tether prior to release. All right. Now let me explain something. You know about the scram tether?
I just know not to drink alcohol.
Yeah, I think we figured that one out. Right? Now, if it comes back and you violate, so the reason I'm not just putting on a sober link where you have to blow is because you don't know how to follow any rules. And that requires blowing 3 times a day. And I know darn well before the week is ended, you will not have done that because you just can't. At some point, you get so stubborn and you just say, I'm not going to blow into this thing. And then we're back here. So I'm trying to avoid that. If it comes back with anything, consumption of alcohol, I'll listen to you, but it's going to be really hard to convince me you didn't do it. Am I understood?
Yes.
Green, please, let's see if we can just make it to the 23rd without any further incident.
We're going to, our absolute best, Your Honor.
The what?
We assure the court we will.
I will.
There will be no issues of bond on 423 is what Ms. Bonfachon.
I heard that 3 times before.
Thank you.
Quit while you're ahead, attorney. Quit while you're ahead. Don't make promises for your client that you do not know that she can keep. All right. I wasn't planning on playing that one tonight. So we're gonna go finish the video that I was planning on playing. Let's see, there's about 15 minutes left, so it's gonna be a little bit longer of a stream tonight. I hope you guys don't mind. Let's see. Oh, I already got that one. All right. Let's go. I don't know what the next couple clips are. I know I usually call these rapid fire clips. There's 3 or 4 just 4 to 5 minute clips. So I think there's one Judge Simpson in here. I honestly don't remember. I don't remember. Let's just go. Let's have fun.
23T00773.
Oh, I gotta talk about this guy, Mr. Malik, in the top right corner. This is not his first time on. This guy, the last time he was on in Judge Washington's court, he did the exact same thing. He doesn't want to be on camera, so he puts up this weird looking mannequin doll. And Judge Washington, she just doesn't want to mess with this guy. And you'll find out why. She just kind of like, you know what? As long as he's talking and he shows his face when he says his name, I'm not going to let this ruin my day. Kind of the stance she's taking.
As well as 23W002349.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Malik McCullough.
Malik McCullough.
Mr. Malik McCullough, you need to be visible on the screen, sir. Thank you. Mr. McCullough. Mr. McCullough.
Yeah.
I'm not certain if you heard what I asked you. I asked you to be visible on the screen. I'm staring at a ceiling right now. Before you turn the camera back to you, I was staring at a ceiling.
Oh, Jeremy laughs almost throughout this entire thing.
We're here for a pretrial today.
Yes, Your Honor, we would like to set this matter for a final settlement conference.
Final settlement conference in this case will be on May 30th.
Yeah,
Ms.
she's
White,
looking at
your client seems to not want to follow the court's directives.
I'm right here, Ms. Washington.
No,
I'll say
we
my
are
name.
aware.
I'll show my face on the video. I'm right here, listening to you.
Mr. McCullough, you do need to keep your face on the camera. We don't wish for the judge to hold you in contempt. Thank you.
I don't think that's what he's thinking. He's like, hey, he's telling his buddy, you need to buy yourself a doll like this. He's
Final
not going to
settlement
take credit
council
for
will be May 30th, 2024 at 11 a.m. Jury selection will be June 7th, 2024 at 8:30 a.m. The jury selection is in person. The final settlement conference is on Zoom.
Oh, please bring your mannequin to jury
Has
day.
Mr. McCullough been making payments on his case in 23W002349?
We did talk about that. Mr. McCullough, did you make a payment?
Yeah, I made a payment on that scam.
Yeah. Yeah, that's what I'm saying. Judge Walsh is like, just get this guy out of here. This is a 3-minute hearing. I am not going to let this ruin my day. Even his defense attorney, Miss White, like, can we just hurry this up, please? It's called his payment a scam because he broke the law. Yep, scam.
I will adjourn this one to the May 30th date as well at 9 a.m. Bond is continued on both.
All right. Again, I don't know what the next one is.
Michael Cook.
Everybody. This is we have a very special appearance in court today. Now, before I play this, clear MH issues here. But yeah, let's go.
Is that Michael Cook in jail?
Yes, ma'am.
Okay, it
Very
looks,
good,
you
Donna.
just look, thank you so much. It looks, you just look so small. All right, Mr. Gramstrup, I have Michael Cook. We will go on the record in the matter 24 TR 288, 24 CF 65, State of Wisconsin versus Michael Cook. The state appears through District Attorney James Reineke in person. Mr. Cook appears by video conferencing in custody in Burnett County Jail. Christopher Gramstrup, newly appointed counsel, appears by video as well. We're set today in these matters.
No. I don't remember what this guy's charges are. This is only about a 3-minute clip. It's what he says. He only says, I think, one sentence, and that's all you need. That's all you need to hear. Kelly, thank you so much. That was my favorite clip I've ever seen in the history of ever. All right. Get ready. I'm just gonna say this. I think we're about to bear witness, guys. I think he has risen. It's a little spoiler about what's about to come.
For initial appearances. Mr. Gramstrup, were you able to go over the criminal complaint with Mr. Cook?
I was, Your Honor. I spoke with him yesterday by telephone. I reviewed the charges and the potential maximum penalties. We would waive a formal reading of that complaint this morning, request the matter be scheduled for a preliminary examination.
All right. Bless you. All right. Are you waiving time limits or within time limits?
He would like it within the time limits if we can do that.
Okay, let's get it within time limits.
I think
Bless
this
you.
is an either or type case.
It's an either or, okay. I can
Fred,
do
thank you.
11:30 or 11:45 on April 11th.
I cannot be there in person at that time. I have an 11:45 here and a 10:30.
Thank you so much, Fozzie. Thank you so much. And welcome to all the new members. You're awesome, Fozzie.
Here.
Mr. Cook, are you okay with both you and your attorney appearing by video conference at that time?
Hey, ma'am, or Your Honor, I got something to say.
Okay,
My real name, I've been using Michael since I was 18. My real name, I'm Jesus Christ, ruler of the world. I'm the only son of God.
all right. I so appreciate that, Mr. Cook. Mr. Gramstrup, I think that means that we're not having a preliminary hearing, correct? I think you're gonna talk to Mr. Cook and you're perhaps going to see if I need to do a competency evaluation, correct?
Yeah, I agree.
All right. All right, so I'm just
You have to love the judge's reaction to it. Oh wow. Well, thank you so much.
gonna call you MC. Okay, Mr. Cook?
Sure.
Not JC, but MC. All right, so Mr. Gramstrup, let's just set a status. Can you do a status at 11 o'clock on April 11th?
Yes, I can.
Zoom is fine. Talk to Mr. Cook. You're gonna update the court as to where we're gonna go and what we're gonna do. So with the statements here today, I'm going to state that the preliminary hearing time limits are waived because we have to address the other matter first. Correct, Mr. Gramstrup?
I agree, Your Honor, yes.
All right, thank you. We are adjourned as to Mr. Cook.
Oh, I just love the judge's reaction. Oh, well, that's great. Thank you so much. All right, we are not going to have this exam. All right, I think there's two more of these quick ones left. I think we have a Simpson. I know we have a Simpson one. All right,
People versus Joseph Taylor. Two cases.
Edward Jerkus on behalf of Joseph Taylor. Better. Your Honor, I was appointed this morning. Ultimately, I need the discovery in this case. So for purposes of today's hearing on the probable cause conference, I'm asking for an adjournment. And I understand that we would like to address bond as well today.
Pardon?
We would like to also address bond.
So you need an adjournment of these proceedings?
Yes, Your Honor.
18th, April 18th. 2024, 9 a.m. Yes, as to bond.
My client is letting me know that his name is Jesus Christ, ruler of our world, son of God. If he says that, yeah, he doesn't say that. I probably shouldn't keep saying that.
Your Honor, as to bond, information that I received is that he does have stable housing. If he were to get out, he'd be living with his fiance. He is currently looking for employment.
His fiance, the one that's the victim, alleged victim of domestic violence? Oh. So there's domestic violence and a fiance. Okay, go ahead.
I don't know if you guys just caught what just happened there. There's a throuple. That is a throuple. And just look at where I paused it. Judge says his face. He's just like, there's a fiance and there's a victim of domestic violence. They're not the same person. Oh, all right. I love these rapid fire clips. Even the attorney is just like, oh, wait a second. I didn't put that together.
Talking about the child.
Yeah, I don't know what that got to do with my fiance.
What does that have to do with my fiance? Nothing.
So from what he tells me, he would show up at the next court appearance, Your Honor, and he'd work with me regarding
Look at Judge
discovery.
Just look at him.
So, and he wouldn't have any contact with the complaining witness.
Response.
Hey, counsel approach.
Oh. All right. Fast forward a few seconds. Yeah, good. Great way to end the night. I don't remember what the last short one is. I don't think I'm gonna be able to top the last three though. I really don't think I can. I should have put that one first.
Record should reflect we had a bench conference in this case. At this time, the court's going to deny any request for bond reduction. Bond will continue as is.
Okay, thank you, Your Honor.
All right, last clip. For everyone who has not heard yet, Debbie Davis will be on my live stream tomorrow night. Will be an interview type stream. If there's enough time, I'll see if she'll react to a court clip with me. Every time I plan on that, it never happens though. So not planning on that. I also don't know how much time she has, but it will start at 8 o'clock, my normal stream time. Yeah. So even if we only get 20 to 30 minutes with her, it'll still be a lot of fun. But yeah, I have no idea how long she's going to hang out. But yeah, Debbie Davis, prosecutor, St. Joseph County, or I guess former prosecutor, I should say. And yeah, we get to ask her all the fun questions about Judge Middleton and, you know, about her running in this upcoming election. All right, last clip. Let's go. You guys are all awesome. Let me make sure I'm up to date on super chats. I am. Fozzie, I thank you for the 5 gifted. Kelly, I thanked you. All right. Yep, we're all good. All right. Let's see. Check one more thing. All right. Let's go.
So that we can get Ms. Banky and Mr. Wasbury on with what else they
Oh yeah, definitely didn't top it off. This guy's just dumb. No, we're just gonna end the night off with some dumb.
need to do for the day. This is 240-11710T Premium Homes versus Corey Nemeth. May I have your appearance, please?
Good morning. May it please the Honorable Court. My name is Jill Banky. I appear on behalf of the plaintiff, Premium Homes. Present on the Zoom is my client representative, Kosai Shamoon, and I just heard Mr. Nemeth pipe in.
He's on by phone and they just relabeled him. Sir, would you state your name for me, please?
My name is James Nemeth.
Did you say James?
Yes. Yeah.
Where's Corey Nemeth, sir?
Corey's out right now because of his he's trying to get his insulin for his blood pressure and his sugar.
No, I tried looking him up. When you're trying to look up prosecutors or defense attorneys, you kind of have to go through their like central, office email and try to get a hold of them. Yeah, so I don't know. I don't know how to get a hold of them because I don't want to just send my email into the basic prosecutor's inbox that they probably get hundreds of emails a day, so it'll never get to them. So if there's a better way of getting in touch with them, I would absolutely love to reach out to them.
Today is a day and time scheduled for the second hearing in this matter. The last time that we were here, Mr. Nemeth indicated that he had retained an attorney. To the Mr. Nemeth that's on the phone, sir, are you a licensed attorney in the state of Michigan?
I'm not.
Okay,
I'm not
sir, the
licensed
court
attorney,
has
but I
not
work
received
with-
any information.
Oh, I'm sorry.
No, you go ahead.
No, I did reach out with Kelly, the investor, and I did also reach out to my attorney.
Sir, I can't hear you. You reached out to whom?
We had a conversation yesterday, the attorney with my attorney, and my attorney was under the where there was Corey's attorney on the 22nd.
Sir,
And,
I'm sorry. You're on the phone. I can't hear what you're saying.
Okay, can you hear me better now? Can you hear me better now?
Sir, my question to you is, are you a licensed
Yeah.
attorney in the state of Michigan? If the answer is no, I can't allow you to represent someone else.
Okay. I was just calling you to just say that he's trying to get his sugar down.
Sir, I'm going to keep saying I can't hear you because I'm in a courtroom and you're on the phone and it's not coming
Yeah.
through clearly. Ms. Banky, have you had any contact from your named defendant?
I was waiting for a pause. Thank you so much, Jenny, for the 1 gifted membership. I appreciate it, and welcome to the new member. There is about 3 or 4 minutes left of this video, so I am going to let it play out. You guys are all awesome. Let's go hang out in Discord. Also, if anybody has any questions they want me to add to the list for Debbie Davis tomorrow night, drop them in the comment section on this video. Email me. Hit me up on Discord. I'll add them to the list. I will add them to the list. All right. So yeah, Discord, Debbie Davis. I think we're good. I'm caught up on super chats. Let's go. All right, I just got an email. Just making sure it wasn't a super chat. All right, let's go.
I have not. I know my named defendant has been in discussions with my client, and I reviewed the register of actions, and I saw that the last time at the first hearing, the defendant said he had an attorney. I did some calling to the attorney. I spoke with him yesterday. He represented to me that he was not formally retained and the counsel would not be appearing today.
This court, in reviewing the file yesterday afternoon, did not see an appearance for an attorney on behalf of the named defendant in this matter. Ms. Banky, how would you like to proceed?
Your Honor, at this time, we are respectfully requesting that a default judgment for possession be entered in favor of the landlord tenant and against, in favor of the landlord, Premium Homes, and against the tenant. There is currently 3 months of rent past due. The monthly rent is $15,000. I'm sorry, there's 4 months past due because it was 3 at the time we filed and then March came due. And the monthly rent is $15,000 per month times
15,000?
Yes. Because this was a deal where the landlord.
Ma'am, no. It's fine. I don't care what the underlying deal is. I just want to get the right number. So
All right, no, I said I was going to let this play out. And yeah, you got a free pause. $15,000 a month. I think they say he owes $60,000 a month. And he didn't even show up to court. He sent, his brother's uncle. That would be his uncle. Okay, I'm gonna stop talking. Danny, thank you so much. Thank you, Colin. Make him pause one more time. I paused it right before you did that. Because my chat's delayed like 15 seconds. I probably paused it right when you did that. So I'm gonna give you credit for that pause. Thank you so much, Danny, for the super chat.
I know what to expect on whatever it is that you file for a judgment. 15,000 for 4 months, 60,000 plus the cost is what?
The cost, the filing fee was $55. And I have my my mailing fees that I paid 2 mailing fees to the court. And I had my own service of process fees, which I had it in my hand, and now of course I don't have that. So it was 55 plus 2 mailings from the court. And I'm looking at the register of actions for that.
Ma'am, let me say this. This case was scheduled at 9 o'clock. It's now 9:20 by this court's clock. The court has not received any appearance for an attorney representing the named defendant. I'll make a note in the file that James Nemeth appeared, but he is not a named party. He's not a licensed attorney in the state of Michigan. Based on that, the court will grant the default judgment for the $60,000 in past due rent that you just placed on the record, along with all recoverable court costs. That's the filing fee, the court mailing fees, the posting that was done at the property, etc. Submitted by on base, ma'am, and the court will sign it. I will note that this court has not received any information from the named defendant about his failure to appear. Sir, you're interrupting me. How can I help you?
I'm sorry. So she sued for 45. Why is it 60 when it's 45 on the thing there? We haven't went over another month. So she's got 60. It was 45. So she said 60.
Sir, are you a signer to the lease?
No.
Okay.
I just don't know what.
Then sir, respectfully, sir, you're here as an observer. If you're not a named party, if you're not obligated under the terms of the lease or whatever the rental agreement is, I'm going to ask that you stop interrupting these proceedings. If the named defendant wants to make himself available to this court, he had every opportunity to appear this morning, or if he was not going to be available, he knew about today's date and he should have made efforts to be in contact or communication with the court's civil department so that his failure to appear this morning would be treated differently. but the court will grant the
apologize to the
default
court.
judgment. Ms. Banky will present it to the court for entry. Copy will be mailed to Mr. Nemeth at the address we have on file. That concludes this matter. You're free to go.